Good morning. Convening the informational briefing on Committee on Health and Homelessness. Today is January 24th, 2023, 9:30 a.m. We are in the conference room 329 at the State Capitol. Thank you, members, for joining us, and thank you to the public that's tuning in. I'd like to start with a brief introduction. My name is Della Al-Baladi. I'm the chair of the Health and Homelessness Committee for the House. Today, we're going to be having our very first informational briefing of the year that's going to highlight one of the top priorities of the House, which is the intersection of mental health treatment with substance abuse and homelessness. This has risen to the top for many of our communities. It's risen to the top for many of our community members. Hence, we're starting this year on this very important topic. Before we get into our presenters, I would like to acknowledge the presence of my members, as well as Chair David Tarnas to my right. And I'm going to allow them to do some brief introductions of themselves. So I'm going to go to my far left, starting with Chair of the House Human Services Committee, Representative John Mizuno.
Thank you, Chair Baladi. Representative Mizuno, I represent Kalihi Valley. Thank you very much.
Vice Chair.
Hi, everybody. Good morning. I'm Jenna Takinouchi, newly elected District 27 representative. That's Kamehameha Heights, Aleva, Pu'unui, Nu'uanu, Dowsett Highlands, Nu'uanu, I know, going up, Pacific Heights, Pa'oa, Punchbowl, and Papakolea.
Thank you, Vice Chair. Chair Tarnas.
Thank you, Chair, for allowing me to join you today. My name is Representative David Tarnas. I represent the Kohala districts on Hawaii Island, and I chair the House Committee on Judiciary and Hawaiian Affairs. Thank you all for being here today.
Bert Kobayashi, representing Diamond Head, Kahala, Kaimiki, Kapahulu.
So just by way of explanation for our online audience, our virtual audience, members may be coming in and out. The House is quite busy with the start of session, even though this is a recess day. And so just like many of our hearings, you might see members come in and out, and we'll introduce them as they come along. I do want to just dive right in because we have presentations by very important stakeholders and partners in the community who help us address mental health, substance abuse, and homelessness in the community. Much of what we're going to be doing here in the Health Committee, and I think broadly in the House, is to look at the programs that we already have in place. Some of them were pilot programs that were instituted really at the onset of or near and about the time of the pandemic. So in 2020, this body passed Act 26 that started a pilot program to address a mental health treatment diversion for nonviolent petty misdemeanors. So for our audience, we're going to be having some judges speak to that first, followed by a follow-up and update on our assisted community treatment law, which was enacted, updated for some, but really enacted in its form in 2013. And so we want to understand what's been happening in that program, and we have representatives from the Department of Health for that. So with that brief introduction, I'm going to jump into first the representatives from the Judiciary. Not listed, but as a representative of the Judiciary generally, I'd like to invite Mr. Brandon Kimura to make some brief comments. And Mr. Kimura, if you could explain what your title is. Thank you.
Thank you, Chair, Vice Chair, Chair Mizuno, Chair Tarnas, Representative Kobayashi. Brandon Kimura, Deputy Administrative Director of the Judiciary. Appreciate you allowing me to begin the hearing this morning, which is just some brief introductions. With me from the Judiciary, Judge Kawamura, who's Circuit Court Judge of the First Circuit, Administrative Criminal Judge, and also Deputy Chief Judge. Also Judge Viola, who is a Circuit Court Judge of the First Circuit. He's a Senior Family Court Judge statewide and is primarily presiding over the ACT cases that we'll discuss later today. And also Judge Shimozono, who's a District Court Judge in the First Circuit and personally presides over many of the Act 26 cases that we'll be discussing today. So with that, I'll just jump right in, and really my role here today is just to share briefly a little bit about some of the more recent efforts that we've been undertaking in the Judiciary and our partnership with the Legislature and the Department of Health and to address some of these issues. And so in 2019, the Conference of Chief Justices and the Conference of State Court Administrators from across the country began a national initiative to focus on the intersection, how we can improve the governmental response to those folks who are suffering from mental health and are interacting with the criminal justice system. So there was a national summit on the mainland that the Chief Justice and a team from Hawaii attended, along with some representatives from our Hawaii Department of Health, Upon returning, we worked in close collaboration with the Department of Health, and the Chief Justice and Governor Ige co-hosted a summit in Honolulu later in 2019, where we brought national speakers, including the Judge Stephen Leifman, who will probably be referenced throughout today or later in this session, who's a real star of leading in this area and innovating the way that courts and health providers work with this population across the country. So that was at the summit in 2019, and at the end of the summit there were two real goals that we had sort of come up with a consensus, that we invited members from the legislature, members from the health community, providers, police, prosecutors, public defenders, and others. And the two goals at the end of that summit in 2019 were to pass legislation or work through legislation that would significantly expedite the way that people with mental health challenges are going through the system. And the second was to convene summits in each of the counties so that we can better understand how the local resources and the challenges and the barriers differ in each county, and how each county would need to identify and craft its own strategy going forward. A few months later, the pandemic hit, obviously, but throughout the 2020 session, thanks to folks up at the Capitol, we were in fact able to pass, or you folks passed, Act 26, which has been tremendous, and that's focusing on that first goal of significantly expediting the time it takes for people to make through the system and to get diverted to the treatment that they can. So that was a significant step forward. We're obviously not all the way there, but it was a great step in the right direction. Throughout the pandemic, Act 26 has been moving and has been implemented, and Judge Shimozono and folks from the Department of Health can speak a little later today onto the effects of that. But as to the second goal, late last year in the fall, Judge Leifman from Miami came back out again, and in partnership with the Department of Health, the Judiciary put on summits in each of the counties, and so we worked towards that second goal. Each of the counties' summits sort of rejuvenated enthusiasm and interest and ideas, re-energized folks about what we may be able to do going forward. And so with that, we've sort of moved forward. And so we are here today and this session, eager to continue to take steps forward. So thank you.
Thank you, Mr. Kimura. So if you'd like to bring up your first presenter, and then we'll proceed. So members, as you can see, this is a statewide, county-wide effort, and really draws upon best practices across the nation. That's the context in which we are operating with this. Judge Kawamura?
Good morning, Chair. Good morning, Vice Chair. Good morning, members of the committee. Again, my name is Shirley Kawamura. I'm the lead judge, the lead criminal judge over at Circuit Court. And I've been a judge for about 10 years now. And for anyone who comes to visit us, or anyone who's curious, or anyone who even asks, I often describe the third floor at Ka'ahumanuhale as the last stop. You know, for many of our folks that appear before us, criminal defendants, it's where they end up after every single institution in their community has failed them. For a lot of our folks, it's their families. It starts off with their families. Their families have failed them. Then it's the schools. Then come perhaps their local communities where maybe they didn't grow up in a safe environment. Maybe they grew up where there's a lot of negative influences. Maybe they grew up and they learned to count by counting drug bindles. That's the kind of folks that appear before us. And on top of that, perhaps their healthcare system has failed us. And nowhere is that more evident than in the folks that appear us with mental illness. So in 2019, when we went to this conference, and Judge Steve Leifman, who really is the preeminent expert in this field, when he told us that the criminal justice system is the repository for most failed public policy, and that there's no greater failed public policy than our treatment of our mentally ill. So right there, I'm listening, right? He got my attention, because that's what I've been saying this whole time. And then he further explains, well, I don't know why anyone should be surprised that our mental health system has failed so miserably. When you apply a criminal justice model to a medical illness and ridiculously unfund treatment and services, that's his words, what do you expect is going to happen? So when he said that in 2019, when I heard that at the conference, I felt it in my bones, right? But yet, I'm sitting there with my judge hat now. So I'm thinking to myself, well, what can judges do? What should judges do? Because let me tell you, we are not comfortable being here today. This is not what judges do. We do not do public policy, not our kuleana. We are very cognizant on top of that, that you folks are the experts at public policy. You draft the laws, which we think are our community values. You give them to us, and we try our very best to apply them. Let me tell you, I'd rather be in our courtroom, in my courtroom with my robe on, presiding over our cases. But here's the thing. When you see day after day, year after year, the mentally ill who come before us, and they're the proverbial square pegs, and we're trying to pound them into these round holes, at some point, I think, even judges have an obligation to stand up and say, I think we can do better. And that's how Act 26 came into play. So we come back from this conference, which was in May 2019, and we partnered with the Department of Health, these folks right here, and we held a mental health summit by the fall. It was hard to get it together that soon. But we came back jazzed. So we partnered with them, we put on the summit, we invited folks from the Department of Health, the Judiciary, the legislature, and our community stakeholders. And then we put together a working group, and we talked about our vision. How can we do this better? That was the only question that we had. How can we do this better? Then we talked about the nuts and bolts, and we got in the weeds, and then we talked about what this would look like day to day in our courtrooms, and that's where you have Act 26. That's how it was birthed. We met and we met and we met and we pounded it out, and that's how it came to be. Now, Judge Shimozono was very involved in the development and the drafting of Act 26, and he's been presiding over that calendar this whole time. So unless you have any questions, I am going to turn the baton over to him. Thank you.
Thank you, Judge Kawamura, and thank you for your collaborative work. Judge Shimozono, and then should I pass out this?
Sure.
So members, you're receiving a handout that just kind of pictorially depicts the very complicated process that occurs. And we will provide these for other members on the committee.
You ready? Okay.
Go ahead.
Okay. Good
Sorry.
morning, Chair Bellotti and other members of the committee. Thank you very much for inviting me to speak here today with you. My name is Ken Shimozono, and I'm a district court judge in the First Circuit, and I'm assigned primarily to the mental health calendar. I also do preliminary hearings, but I primarily do the mental health calendar. And I'm here to share some information about Act 26 and how it's working today. But I think before I get into that, I think it's really important for everyone to understand how the previous system used to work with regard to persons charged with nonviolent petty misdemeanors. And so I handed out a chart, and the first page, two flow charts. The first page is how cases are currently handled for misdemeanor cases and how petty misdemeanor cases were handled prior to the implementation or passing of Act 26. And what would happen previously is a person would be arrested for a petty misdemeanor nonviolent offense such as a park closure or open container or a criminal trespass in the second degree, being on a somewhere at 7-Eleven when they were told previously to leave. And they're brought to district court for their arraignment because they're not able to post their $25 bail or $50 bail, $100 bail. And that person meets with their attorney, quite often a public defender, a deputy public defender, and the public defender is unable to communicate with that person because of mental health issue. And defense counsel will ask the court for an order for an examination for fitness, and also penal responsibility. Now, I'll tell you, as a former public defender, I can tell you that I had firsthand knowledge that when these defense counsel meets with someone who's charged with a nonviolent petty misdemeanor, or any petty misdemeanor for that matter, you're going to try your best, really, to just get this person through the system because of the way the system previously was set up for nonviolent petty misdemeanors, which I'll go into in a second. So they're trying their best. They'll even come to the initial appearance and say, you know what, can we have like one more day continuance? Because I think, you know, if I try tomorrow, you know, maybe, and they'll try their best to just get them through a change of plea, credit for time served and out, okay? So what would happen though is, you know, sometimes they can't even get through the colloquy, so they have no other choice but to ask for a 704 mental examination on fitness and penal responsibility. The return date is set 30 days out, and in a vast majority of these cases, these people don't have homes, they don't have jobs, they have prior records, so the intake service center will recommend to confirm bail. In other words, don't release them. So oftentimes the court will have no choice but to follow that recommendation, and they'll set the return date out 30 days. In that 30 days, what's happening is the probation division is gathering information from previous service providers, if any, hospitals, physicians, and they review the records, the examiner reviews the records and has to interview the person at OCCC. Now on the return date, the parties come to court and state their respective position on the examiner's report, if the report has been completed. But many times, in fact, I'd say a majority of times, the reports are not completed within the 30 days because there's consent forms that haven't been signed or there's information missing. So oftentimes it's continuing another 3 or 4 weeks. So that's 7 to 8 weeks that the person is waiting at OCCC for a report to be done. So let's say the examiner finally completes the report and has concluded that the individual is not fit to proceed. If one side or the other contests that hearing, then we have to set a contested hearing out, which can be anywhere from a couple of days to a couple of weeks, depending on the examiner's availability. Defendant is sitting at OCCC this entire time. So after the contested hearing on fitness, or if there's a stipulation to fitness, then the court finds, let's say, a lack of fitness, and the court finds the defendant is not fit. The court will either release the person on conditions, which is usually rare, or commit the person to the Department of Health, Hawaii State Hospital, for treatment and order a second exam. That exam is now 60 days out, and takes place with a hearing date 60 days out. And on the return date 60 days out, if the person is restored to fitness, what happens a majority of the time is the defense attorney and the state work out a deal, credit for time served, the person is released without any services, or they're just trying to restore them so they can get fit, so they can do their court hearing. They are then, they plead out, credit for time served, and out they go, only to be rearrested a few days, few weeks, maybe a few months later, and then the cycle starts again. And so I think all of you are aware of the cost to house an individual. Now it's at $247 a day at OCCC. At Hawaii State Hospital, the cost is, my understanding is $1,125 per day, per patient. So as you can see, that's the, prior to Act 26, that was how people charged with things like sit-lie or any nonviolent petty misdemeanor were typically handled. Since the passage or implementation or effective date of Act 26, which was September 15, 2020, when someone comes in now for a nonviolent petty misdemeanor and there's appears to be a mental health issue, first of all, we're seeing a lot more requests for these because the attorneys are aware of the shorter time turnaround for these cases. And what happens is at the initial appearance, the defense counsel will move for an expedited Act 26-704 exam. The exam, we have a doctor with the Court Evaluations Branch named Dr. Bautista Torres, who's very, very accommodating. She's been very diligent, and she's always agrees to do, says that she can do the examination and turn in a report within 2 days. So quite often, or most times, we'll order a return date in 2 days. Sometimes that person is in such bad condition or in crisis that we order that they be committed right there from cell block to the Director of Health for finding necessity, depending on their condition. And we'll set a return date in 2 days. Even if they do remain at OCCC, return date is still 2 days out. And Dr. Bautista Torres will either go to OCCC or to the hospital to interview the person. In 2 days, we come back and we get a report, and quite often it is a finding that the fitness is an outstanding issue and or they are not fit to proceed. From there, pursuant to the statute, we commit them to the Director of Health and we set a return date in 7 days, or soon thereafter is practical. If it falls on a weekend, of course, then we'll wait till the Monday or the next business day. We come back in 7 days from that first exam return, and we see what the report says. Quite often, they're still found to be unfit to proceed. And at that point, pursuant to the statute, the case has to be dismissed. The difference is that in that 7, sometimes up to 10 to 12 days, the hospital has had a chance to stabilize the defendant. And in most cases, I can say in my experience, they're on the, we do a lot of it through remote hearings, which is also a time saver and money saver for all parties concerned. And we do these hearings, and for the most part, the defendants appear to be stabilized. They appear to be, they have fresh clothes on. They appear to have been showered, and they seem to be in much better condition than when we see them at the initial appearance, oftentimes. So, and then of course in those 7 to 10 days, they're being assessed. They're given treatment. They're also being directed to services, and so from there the case is dismissed. And so we've now resolved the case in approximately 10 to 12 days versus 90 days or more. And so I'm not sure if you've had a chance to see the latest judiciary report on the savings. And I think there's different takes on it. Everyone has a different take on Act 26 and whether it's been successful. It's really only been really implemented for approximately 2 years, from September 20th through September 2021 would be 1 year, and September 21 through September 22 is 2, so a little over 2 years. And in that time, in my view, when we were discussing Act 26 before it was implemented, I think from my point of view, the goal was to reduce the amount of time that people were spending in OCCC. I think studies have shown that mentally people with mental health issues, especially when they're in crisis, putting them in a jail situation actually makes their situation worse than when they went in. And so part of, I think, the goal of Act 26 was to reduce the amount of time they're spending incarcerated. It was also to reduce the amount of time they're spending at Hawaii State Hospital, all for 90 days for a 30-day petty misdemeanor. That's the maximum you can spend in jail. It's also to possibly save money for the state, where they could take those resources and put those towards services rather than incarcerated or hospital. And finally, to get people more treatment than what they were getting. And so I think they have, Act 26 has hit on all of those goals. I think if you ask others, we never thought it would be a silver bullet that would wipe out our mental health problem. I don't think that's going to happen overnight. And but I think that Act 26 is definitely a step in the right direction. And so from my perspective, I think it's been very successful. Yeah. So I'm happy to answer any questions you may have on either how we did things previously, how things are going now, or the flow charts that I handed out.
Thank you. I'm going to open this up for questions, and then we're going to be then going and moving to the Department of Health officials. Members, we have our judges here with us. They are very busy, and we had to pull them out of court. So we have them for about another 20 minutes, and if they are able to stay, some of them will stay, but if they also have to leave, I understand and we'll dismiss them. So really, this opportunity, members, is time for you to ask any questions.
Right.
And I will defer to our senior member, Representative Kobayashi.
Judge, you said that Act 26 is, quote, very successful. Does it need changing?
Does it need changing? I think it could use some changes. I think that if we could reach more people with it, and by that I'll give you an example. Just this week we had an individual who came in with something like a park closure, which is a petty misdemeanor nonviolent offense. But probably because of their mental health condition, they refuse to provide their ID or information to the officer. So the officer then arrests them also for refusal to provide information. It's a misdemeanor. Okay, so because of that, and Act 26 does not apply to misdemeanor, only petty misdemeanor nonviolent cases. We can take care of the park closure case through Act 26, but the refusal to provide identification will go through that first page of the handout. You know, so they're going to look at 30 or 60, 90 days possibly. 30 days at OCCC and 60 days
So
at the hospital.
what would be your suggestion? Add all misdemeanors or only a certain category of misdemeanors?
Well, I think initially I think we could look at including nonviolent misdemeanors. I think that would be the first, the initial step is to possibly add nonviolent misdemeanors to the list of cases that are that Act 26 could apply to.
And so, I mean, here we mainly do two things. We change laws and we give money. You need any money or resources? Obviously, I think.
You mean to the judiciary? I think I think what you mean is yes. I think to have more money for the Department of Health to have more crisis centers, to have more treatment available, to have more people like I think they do have funding for what's called forensic peers, and forensic peers are, and Dr. Curtis and Dr. Chapman, correct me if I'm wrong, but I first became aware of this concept of forensic peers when I heard I went to a couple of Judge Leifman's. I went to one of his seminar in Miami, also when he spoke here. But forensic peers are individuals who have come through the criminal justice system. They have had or have mental health issues, but they have received treatment and they come back and they serve as forensic peers and they meet with people who are going to be released into the community. And they say it's a tremendous eye-opener for the people who are working in mental health, because the defendants seem to be much more open to speaking to someone who's they can kind of relate to, it's been through the system, and they're much more open to services when they speak to these forensic peers. And the Miami model is they'll actually come to court and they'll have like a toiletry bag for them, they'll have a sandwich, they'll have a small amount of money for bus fare, and they'll actually escort them to from the courthouse to their first wherever it is that they're getting services from. So something like that would be helpful to I think the Department of Health. Well.
So this report says on page 5, Big Island, no forensic peer specialists on the Big Island. Obviously, Big Island has had a few of those people who would qualify. Present company.
Right.
Members, I'll say thank you.
Thank you.
Representative Kobayashi. So some of these questions can be directed to DOH later, and we're going to have an opportunity
Okay.
to actually question both judges and Department of Health. But any further questions? I have a question on this issue of the charge. So for example, if we see, many of us, especially in the Marine Corps, see the acuteness of individuals, and we see the recurring acuteness of people on the street. I, for example, in right outside of Makiki, would someone who is partially naked running around the street, would that be considered a public disorder? Possibly, if they're screaming and running around and partially naked, and would that be considered a nonviolent petty misdemeanor that could fall into this category if that person was picked up?
Okay, so what you described, and we're talking generalizations, right?
Yes.
But there's that situation. I see that, and often the charge is disorderly conduct.
Disorderly, okay.
Because they're causing alarm to the public.
Concern.
So the police arrest them for disorderly conduct. So that would fall under Act 26 currently, nonviolent petty misdemeanor.
Okay, so in that example, that person is picked up and transported, and I know this is a little bit out of your zone, but I see it in some of the report. How does that person get from that situation into your courtroom? I mean, they're not taken directly, they're picked up by local law enforcement, counties, then where are they taken and how are they taken to wherever they go?
So they're taken to HPD cell block and they're processed, fingerprinted and so forth. And then from there, if their bail is set, and then they can't post bail. So when they can't post bail, they have to be brought before court within 48 hours. So that's how they end up in district court cell block. So they're transferred from HPD cell block to district court cell block. And then that morning, they're brought before the judge. Well, it's by video. So they're brought before the judge, video. They're downstairs, the judge is upstairs, and they address the case. And the public defenders will have, they either go down or they speak with them on the phone. And that's when they assess, I guess the attorneys assess, whether this person may have a mental health issue. And so that's where they ask for the expedited Act 26 examination.
Okay, I guess, you know what, and I apologize, but I really want to kind of clarify this because this may be bleeding into kind of the other section. But if that person needs medical care, but they're clearly like in some kind of state, is that called the MH1 and then they're then transported possibly to a hospital?
Okay, so when you say they have a medical issue, do you mean like a physical medical issue, like they've got scrapes and bruises or things like that? Because
Yes.
in that situation, they will many times they'll stop at one of the hospitals first to get medical treatment, and then they'll bring them to the cell block. Now, if they're and perhaps Dr. Curtis can elaborate on this on the different classifications and what happens if someone is really having an episode.
Okay, we'll come back to that because I think one of the things that I'm trying to understand is that, there's clearly a need for stabilization beds, but is there also a need for some kind of drop-off centers or other things that might be a better alternative than even going straight to jail? And I don't know what that situation is. So if you can speak to that, or should I defer that question?
Well, I think maybe you can defer, but I would say just briefly on that yeah, if there were some kind of alternative or drop-off center where the police officers could do that, and I think they have a model like that in Arizona, and I believe they also have a model like that in Miami, where they do have some alternative to draw, especially when it's when it's that kind of situation where really there's not a direct victim, and so or sit lie or criminal trespass or something like that. I'm talking about the criminal trespass where they just happen to wander onto a 7-Eleven after they told not to be there. I'm not talking about going to someone's residence.
Yes. Yeah. Okay. One more question. Is there any further questions on?
I have one quick question.
Question. Go ahead.
Thank you, Chair. I was just curious, there's a great deal of skepticism among some of the public defenders and the prosecutors about this in the very beginning. What would you say has been their experience in the court and your interactions with them through use of Act 26?
Okay, so from the public defender's perspective, I think that they would say it's a very positive thing, and I say that because they're asking for Act 26 examinations more than they did before. And I have meetings regularly with the supervisor, along with the prosecutors and Dr. Curtis, and they are very supportive of it. Well, I'm speaking just now for the public defenders.
Yes.
They see the benefit of it, and they see that they did have to give up something because they the court's committing them to the hospital, really without any kind of evidentiary hearing. And I think they balance that, because it's generally only for 2 to maybe 10 days that they're in the hospital. Versus, sure, we can follow the statute, but they'll end up in the hospital for 60 days. So I think overall, I think that they do support Act 26. And from the prosecutor's side, I haven't heard maybe directly, and I think they submit their comments on this. I think that I would imagine that there are things that they would like to see. In fact, I can recall some comments they made about having, their frustration is that it's too short of a time period to really stabilize and assess them and get them treatment. I think some of them would like to see a longer period of time that they're committed to the hospital. But I think overall, I think it's a cost and time saving to the Office of the Prosecuting Attorney as well.
Thank you. Thank you, Chair.
And if I may say that.
Yes, please go ahead.
There have not been, I can't recall a contested hearing on the fitness issue. I'm not, I don't sit every day, so I'm not saying there's never been a contested hearing. I sit 4 of the 5 days. But in my experience, there hasn't been any contested hearing on the finding of fitness or lack thereof.
That's important, very substantive result, because I know there was some concern about that, 2-day turnaround for a determination. So, thank you. Thanks for that information.
Okay.
Back to you, Chair.
Thank you. Members, any questions? This is a rare opportunity that we have these judges in front of us. So I have a bunch of questions, and I'll keep asking, but please, members, wave your hand if you want to ask a question. In the report, Judge, and I really appreciate that there's actually a county-wide perspective on this. So this is not just about the First Circuit on Oahu. So in your report, and if you can't answer, and to tag a friend, please feel free to do so. But in the report, in the Third Circuit, so this is Big Island, it says that there's an indication that the police have no legal authority to force a person to enter a police car for transport absent grounds for an arrest. So what is that speaking to? Is that like, my understanding is if you see someone, they're committing public disorder, that's the grounds for arrest, and you should be able to then take them. Is that because the police don't feel like they have the authority in that instance to do that?
What I gather from that is that the police may not feel this. They can only do it if they have probable cause to believe a crime has been committed. And in this case, the person is having an episode. They don't think that that rises to the level of a criminal offense and probable cause, so they can't force them into their car because they've not committed, or in their view, there's not sufficient probable cause to arrest them.
Sure, okay, but like the hypothetical that I talked about, which is where it's disorderly conduct and someone clearly is having an episode, and that's a petty nonviolent misdemeanor. The previous sentence of the report says, in discussions with the police, we are advised that they are unable to divert individuals to DOH stabilization units if the individual does not agree to go. So is it that there's a lack of DOH stabilization units, or is there something in the law that we have to authorize the police to be able to do the transport?
Okay, so can I just back up first?
Okay.
I think there's as a clarification, like, in that example you gave me about the person, like, acting out, or, it's very subjective on whether or not there's enough probable cause to believe that there's a crime of disorderly conduct. Disorderly conduct actually is quite difficult to prove beyond a reasonable doubt.
Okay.
And so some officers say, hey, I don't think there's enough there. Other officers might be, hey, they just put in some magic words in there, the buzzwords in their police report, and they think that's sufficient to take them into custody. So that's, I think, why the difference is, some jurisdictions maybe they're a little more lenient before they say it's crosses the line, and other jurisdictions maybe not. So,
and maybe what it speaks to is that there needs to be, again, a drop-off center somewhere where clearly there's someone in crisis. Maybe their actions don't rise to the level of criminal conduct, but they need to go somewhere. Maybe that, so it's outside of your realm, because that person never actually gets into the system.
Correct.
Okay. Next question. In the Maui circuit, there was some indication that there is a center that's going to be stood up as a Maui Second Circuit, right? I can't find it on my.
Yes, Second Circuit.
Has the judiciary been involved in discussions about what that Maui Center is going to look like and how it might be able to provide a continuum of services or drop-off areas or I don't know what for this part of the program. And I see Mr. Kimura stepping up to the plate.
I'll defer to, please, go ahead.
Thank you, Chair. Thank you, Judge. We are continuing to communicate with DOH about I believe it's called CCBHC, Certified Community Behavioral Health Center. That is, I believe, largely, if not exclusively, funded by federal funds. And so they're lead on that, point on that, and they continue to update us with the progress. But I think that's probably, they can elaborate on that further a little bit later.
Okay, and I don't want to lose you. So this kind of model that's being built and developed on Maui, in your studies of, with Judge Lightman, with your review of what's best practices in other states, is this an opportunity for us to build something correctly that can help this population? Whether or not they intersect with your judges, is this an opportunity, and do we need to focus on this?
I think and I'll let, again, DOH elaborate further on their perspective as well. I think the CCBHC is a tremendous opportunity for us, particularly for Maui County. I know that other circuits and counties would be very interested. That said, I don't think that is necessarily the only way to do it. I think it is a significant step forward, and my understanding is that about 30 other states may have those, and this would be the first one in Hawaii. But there are other thoughts, like along the lines of what you were talking about earlier with the drop-off center. Arizona is a jurisdiction with a tremendous model for the country, where folks who, like as you're suggesting, maybe some of their conduct, it serves a wide variety of purposes. So for some, it's for folks who appear to have mental health challenges or clearly have mental health challenges, but perhaps their conduct does not rise to the level of criminal activity. Then either a law enforcement or another, community member, if they are able to get this person to that drop-off center, they can be assessed, they can have their, can be stabilized, and they can be have a warm handoff directly to the treatment. In other instances, folks who have committed something like a nonviolent petty misdemeanor or some measure of criminal conduct, but the officer recognizes that person is in mental health distress or is having some challenges, that officer could take this person to the drop-off center and divert them to treatment before they even enter the system. They're not booked, they're not brought before a judge, they're dropped off, they're treated medically, and they're sent on their way so they can be addressed appropriately. Now, obviously, precautions need to be in place to make sure that that's done right and that serves the right population and doesn't over-include. But that's a model that the Arizona jurisdictions have been working on, and we're closely looking at that as well.
Okay, thank you, Mr. Kimura. Members, I want to put a pin in it. What he just discussed was law enforcement assisted diversion. I think it's called a LEAD program, and I do believe that even pre-pandemic, that was another one of those things that we funded as a pilot project. So we do have, and what Mr. Kimura has stated is that another key partner in this is law enforcement, because they're the ones who are on the ground level interacting with individuals who are clearly suffering mental illness in the community. So for a future briefing, we may have law enforcement come forward to provide their insights. But before you leave, Mr. Kimura, any other questions? I do have one more question. So in the report, it says 86 members who went through through Act 26 were discharged and linked to service. Approximately 76 of those discharged to the community have not been rearrested. That is a stunning figure of success. So I'd like to know, where are those 86 people being discharged to? What is the services that they're going to? What does that look like? And then, if 76% of those are not being rearrested, what's happening to them? Where are they going, and what do we need to fund more to get more people there? What does that look like?
I know Dr. Curtis can speak a little bit more about updated stats. As far as where folks are directed to treatment, I'm not sure who would be the best.
Okay, before we bring them up, so is when they are linked to services, at that point, is it the judiciary determining what programs they're going to, or is that the Department of Health in consultation with the patient deciding which program fits for them?
I believe that's primarily DOH.
Okay.
DOH.
All right. Okay, this is really important, because if these are the services that we're lacking and we need to fund, we need to be clear that that's what we need so that more people can move through this program, and that we can grow that 76% of those discharged to the community who have not been rearrested. That's the other piece of this that's super important.
Let me ask one more.
Go ahead.
Thank you. Just for the judiciary, before we lose the judges back to work in the courtroom, and you, Brandon, I'm concerned about the neighbor islands because they've got a lot less resources than we have here on Oahu. So I would really look to you to ask what is needed in your shop, in the judiciary, and I'll ask the same thing of DOH, because I think the neighbor islands are struggling. And perhaps you could speak to this. I know I read the report, but would you say that there are resources needed within judiciary in the neighbor islands and the other circuits?
I think one of the difficulties that I think is something that we're certainly open to doing is that some of these Act 26 cases, they do take more time in terms of judge and staff. They take more court time because people are more involved, and there's an even deeper level of analysis and assessment and discussion about the individual circumstances. So that is one thing that we're working through, but as Judge Shimozono and others have shared, we are eager to do that because we see this as a step in the right direction. My understanding, and Dr. Curtis and Dr. Champion can elaborate further on the neighbor islands, is that one of the primary challenges there is stabilization beds, places to have these folks go to get the treatment they need, human resources, if you will, whether it's a docs of some kind to do the assessments and to do the work and to bring the staffing in. They can elaborate on that a little bit further. But I will tell you that one exciting thing that we are looking at and are moving forward on is that with the summits in each of the counties this past fall, a common denominator, or a common answer from all of the counties is to reinvigorate efforts on jail diversion. And so that's a collaboration, again, between our courts and DOH and others as well. So the neighbor islands are moving forward on that, and I think at least Kauai has got theirs back up and running. And the Maui County and Big Island are continuing to work towards that as well. So that's something that the neighbor islands are doing actively right now without the additional resources for DOH. But those other things would be absolutely critical, because one piece about the jail diversion is you've got to divert them to somewhere, and that's where the resources come in again.
Well, if you find that there are particular needs in the other circuits in the neighbor islands in judiciary, please let us know. I mean, because this is a successful program, we'd like to enable you to continue it, and we'll follow up with the Department of Health on the needs on the neighbor islands as well. Thank you, Brandon. Back to you, Chair.
Thank you.
Mr. Kimura, I hope you'll stay, and I hope the judges, they are invited to stay for as long as they'd like. I'd like to give them some moments to close, but then before you leave, Mr. Kimura, I participated in the summit at the Supreme Court, and I believe Chair Joyce San Buenaventura did too at the same time. So as these summits occur on the counties, if there is an opportunity to invite area legislators, I think this is a really good opportunity to continue the collaboration. And please reach out to our neighbor island representatives, and I'll say senators as well, but definitely our neighbor island representatives, if they can be part of the conversation, because I think, again, it's an all hands on deck, statewide and countywide. Before we move to the next one, if there are any other comments by any of the judges who are here. Judge Kawamura.
Sorry, this is an opportunity for us too, that's why. So, I'm kind of a nutshell person. Okay, so this is the way I see it. Act 26, this is what we used to do for certain offenses. They come in, we're a district court judge, someone is clearly either having a psychotic episode or they're mentally ill. What did we do before? We sent them to HLT for 30, 60, 90 days to go talk to a doctor to see if they were fit to go through the court proceeding. That's what we used to do. And what is that? When I talk about square peg, round holes, that is coming from a point of view of a criminal justice system, because all we care about is getting you through our court hearing. It's not coming from that defendant's point of view or the community's point of view. What really makes sense is not to go down this forensic competency. Are you fit? Can you answer the judge's question? Do you know what everybody's role is in court? Do you know what you're pleading to? Instead of going there and taking 30, 60, 90 days at HLT to get there where you're not getting any treatment, we're saying, hey, we're going to prioritize treatment. We're going to try to square out the holes and try to fit it with you. That's what Act 26 was all about. So anytime we can prioritize treatment for certain groups of people, we're all for that. Now, the question I think for the legislature is, who is that appropriate for? right? Because right now we got the nonviolent petty misdemeanors. For a murder defendant, for example, you are going to have that person examined by the forensic examiners because that person has to go through the competency process and they have to stand trial if they are fit or eventually can become fit. So the question for you, to me, for you is, what group of people can we prioritize treatment first? For me, I sit in felony court. Can, for example, nonviolent drug offenses, drug possession cases, where really the guy just has a pipe with some residue on it. Very common in our courthouses, you know, maybe they don't have a violent past, but they do have substance abuse concerns because 70% of our folks, if they're mentally ill, have a substance abuse disorder too, a co-occurring disorder. So can we loop those folks in? But again, that's not a question for me, it's a question for the legislature. What types of people for whom we can prioritize treatment over going through the court hurdles, the court system. And if we do that, if we expand it, you know, we're definitely going to have to tinker with, because we're talking about a felony, so I'm sure we're going to have to tinker with the time limits and how long you can be held and at HSH following your commitment there. And how much teeth can we give into sort of ordering treatment, because during that time when you're being assessed at HSH, whether it's for 7 days or however much long you want to make it, they should be getting critical care, getting wound care, all their medical care, and they're getting set up with community services, right? And how much teeth do you want to give it to make the community services stick? Because that's another issue that you folks could tinker with or think about to place into the statute if you want more teeth in it. Now, in the meantime, Department of Health is assessing whether someone, for example, is in imminent danger to themselves, and they could go the civil commitment route. In which case, again, we're talking about funding. It's hard to go civil commitment, and as the Department of Health, to suggest civil commitment when you know you don't got crisis beds. You don't have anywhere to put them. So that's, I'll leave the funding, that portion to them. But again, anytime you want to divert into treatment, and then on top of that, that's where the drop-off centers come into play, because we're not even talking about court at that point. The officer is in Arizona. When you have that person on the street, they don't know what to do with them. They certainly are able to take them to their drop-off center. In fact, they prefer that because they don't have to arrest somebody. They don't have to go back, hold them in cell block, go through Miranda rights with them, go through the police reports with them. That takes hours for a police officer. So it's much easier when in Arizona, they drop them off at the drop-off center, spend 5 minutes there. They get critical care, and the police, law enforcement is out the door. So even for law enforcement, they prefer that model because it's much more efficient for them. And the person is diverted completely from the criminal justice system. You're not talking about competency, you're not talking about court hearings, you are talking about direct treatment. So again, I think the question to be posed is, for what types of offenses, for what types of scenarios is that appropriate?
Thank you, Judge Kawamura. I think you've put that very succinctly and given us the questions that we have to mull over and the policy decisions we have to make. I want to transition, if there's no further comments from the judges who are present.
Thank you.
Thank you. And please, you're welcome to stay as long as you can. We certainly appreciate the wisdom here. If I could turn it over to our Department of Health guest, Dr. Amy Curtis and Dr. Mike Champion. I believe, Dr. Champion, you're going to start it off, so if you'd like to come forward. And members, I believe we have a short PowerPoint. Or a PowerPoint. And we will also, again, provide these to the members who are not present.
Thank you. Aloha. My name is Michael Champion. I'm a psychiatrist, and I serve as the medical director for the Department of Health's Adult Mental Health Division. And today I'm going to be providing some information about assisted community treatment and give some updates about that. We did develop a PowerPoint presentation for you. You have printouts. And in the process of developing it, we wanted to have this be a resource for you, so it's very detailed, but I'll hit the highlights, and we certainly can provide more information afterwards if needed. I'll be covering some background about ACT as a concept and how it's utilized, how it works here in Hawaii based upon how it's outlined in our revised statutes, review some of the challenges and successes we've found in implementation over the last 10 years, and then end with some learnings and recommendations. So first of all, let me start, and I also wanted to say thank you very much for the opportunity to testify, Chair, and Vice Chair members. Thank you for the opportunity to talk about this very important tool for clinicians in the field. So some background. Currently, outpatient commitment statutes exist in most states around the country, and its implementation varies across the land, but it's typically called outpatient commitment or assisted outpatient treatment, so you'll hear AOT when talking about this modality. Here in the state, it's called assisted community treatment. So what is at its very core is court-mandated treatment in a community mental health setting for people who meet the criteria for this kind of treatment, and we'll review the criteria in a moment. Primarily, it provides a mechanism for clinicians to engage individuals in treatment when those individuals have a real diminished understanding about their need for treatment or clearly don't believe that they need treatment, but if they meet the criteria, it provides a pathway to get there. The goal is to improve the quality of people's lives through engaging them in treatment, but also to make an impact to support individuals so that they're not continually decompensating and cycling through systems of care or contact with law enforcement and have negative outcomes as opposed to be able to have successful recovery in the community. One important thing to keep in mind and understand is that ACT, or assisted outpatient treatment, is one aspect of providing treatment over an individual's objection. This is, so let me talk about it in a hospital-based setting. There's civil commitment when somebody doesn't agree to be in the hospital. When somebody is in a hospital setting and they need medication and treatment but are objecting to that, there's a pathway through the courts to get a judge's order for treatment over objection in the hospital setting. There's also involuntary transport in the community. It was mentioned earlier, MH1, a consultation with a mental health emergency worker, and then an involuntary transport. But that's all based on when you're brought to a facility or you're staying in a facility. Where ACT comes into play is when an individual has a history of not doing well, of not having insight into the need for care, needing care, but they're going to be moving into an outpatient environment in the community or are in the community. So this pathway allows there to be a judicial order to enforce treatment when somebody is in a community setting and act within that community setting to engage people in treatment over their objection. So how does it work? The first thing, if you go to the second slide, is a very detailed list of the criteria. And I'll just hit some of the highlights. And again, we put a lot of detail in there as a reference to you. The criteria are that somebody is mentally ill or suffering from substance abuse, that there's a need for treatment to prevent a relapse or deterioration, and that deterioration would predictably result in the person becoming imminently at risk for danger to self or others. So the key difference here is, like in a civil commitment statute or transporting somebody in for an emergency examination, that somebody at that point in time is at imminent risk for danger to self or others. Where ACT comes in is that it allows for people to be engaged in treatment and a pathway towards treatment when proactively thinking ahead that somebody may decompensate if they don't get the treatment, and to be able to act and give treatment at that particular time. So it has to establish in the criteria that somebody does have a mental illness that actually caused the person, due to their lack of insight, to refuse important treatment. There's a history of a lack of adhering to treatment for their condition, which resulted in them being dangerous in the past, and that other alternatives that are less intrusive have been considered. So those are the criteria that Judge Viola and others in the family court are looking at to determine whether somebody is eligible or not. So go on to the next slide. I want to quickly run through the process that's outlined in our statute at this particular time. So there has to be an examination by a psychiatrist or a APRN RX who prepares a certificate about eligible diagnosis and also their history of noncompliance with treatment that initiates the process. A petition can be brought by any interested party and filed with the family court. The family court determines if there is the existence of a guardian ad litem, and if not, appoints a GAL. Go on to the next slide. In terms of legal representation for, in statute, term the subject of the petition, is that they're entitled to assistance of an attorney, and they may contact their own attorney. One is not appointed for them, but they may contact an attorney to get assistance if they would like. Now, during the hearing, the person is not required to be present if they refuse. However, the guardian ad litem or guardian will be present. The psychiatrist or advanced practice nurse who assessed the individual and developed the treatment plan will testify during this hearing and will present a written treatment plan about what's proposed if the order is granted. It will also have to list an identified designated mental health program that is going to take responsibility and be accountable for delivering the care during the period of the order. On to the next slide. This summarizes what happens when an individual who is receiving treatment and is subject to a order for ACT does not comply. So when somebody, the order allows for the psychiatrist or advanced practice nurse to prescribe treatment that is listed in the written treatment plan. The key issue is, and this is basic clinical practice anyway, is to try to engage an individual in that recommended treatment and have it be voluntary and develop an alliance to hopefully have there be a co-vision about how treatment is going to be administered. But if it's not, and for instance, a common treatment is an individual is getting a long-acting injectable medication, an antipsychotic medication, or a mood-stabilizing medication. And so there's a regular routine for that to happen. They get an initial injection and a series of injections over weeks to months. And if an individual says, no, I don't want it anymore, they don't start showing up for their appointments, there's a mechanism to transport that individual to the mental health program or to an emergency department for an evaluation. Now, once they're evaluated, if it's determined by their treatment plan that they need that medication over their objection, that forced medication can only happen in an emergency department or if they're admitted to the hospital. So in other words, not in an outpatient clinic or not in the community. All right, we'll go on to the next slide about disposition. The order itself will have a treatment plan attached, and it will also list the designated psychiatrist or advanced practice nurse or the designated mental health program, and the period of time for the order is no more than a year. And I just want to acknowledge that that's my summary, but thankfully we have Judge Viola and other members of the judiciary can go into much more detail or answer questions about that because they're dealing with that every day. So let me move on to implementations and challenges in the implementation over the last 10 years. What we found over the last 10 years is that uptake of this tool and its mechanism by mental health providers has not been robust. And one of the root causes of that we have found is that providers in the community or mental health programs are not widely familiar with the procedures related to ACT and also the rationale for ACT and how that fits in as a tool in a kind of suite of tools that you can use to engage people who are needing this kind of treatment, sometimes over their objection. Some of the challenges we've also found has been that the legal representation for any interested party who's going to bring a petition, and the language was changed in previous sessions to go to any interested party can bring a petition, but key issue is going to be legal support for bringing the petition. The second thing is having identified designated mental health programs and also independent practitioners who treat very ill individuals in the community who are willing or able to implement this tool and adhere to the procedural requirements. Another issue is the logistics of transport, or bringing in when somebody is not complying with the treatment order, bringing them into a point of care into the emergency department for emergency examination or involuntary medication. And the last thing is procedures in an emergency department, if it is going to be administered in an emergency department. Dr. Curtis and others have brought up earlier that a clinician who is in the emergency department and they're seeing an individual who is brought in may not know the history, may not know the last time that they got a shot. If there's an interval for the shot that's every 3 months, determining whether it was given 2 weeks ago, a month ago, you want to be very, very careful that you don't double up, particularly in long-acting medications, because when you put the injection in, there's a delayed time release. So if you double up on a dose, you can have a double up on a dose of medication that may be very, have a big impact on somebody's heart or their organ systems that will be then released over a months-long or weeks-long process. So we have to be very careful about that. And not all emergency departments or clinicians in emergency departments are readily able to step up and say, yes, we know how to do that, or we're willing to do that. So there needs to be some work done in that area. And the last slide are some recommendations for implementation moving forward. And those directly flow from the challenges that we've identified. One is to enhance access to legal representation for the petitioners. The second is to develop a mechanism to provide education and training across the board to providers, emergency departments, potential petitioners, designated mental health programs. And Dr. Curtis can speak in detail about this later if needed, but there is a bill, SB 987, that proposes to appropriate funds to the DOH to provide that education and training. The third is identifying a roster of designated mental health programs who are ready and willing to handle the clinical aspects and the procedural aspects of successfully administering an ACT order. And then the last recommendation is to develop a mechanism to provide ongoing technical assistance and support for the implementation of ACT, not only the petitioning, but the implementation when it's needed for a person's treatment over objection. We're happy to take any questions that you have.
Members, so we're looking at the ACT program, Assisted Community Treatment, as enacted in 334, Section 334. Any questions? Immediately, Chair Tarnas?
Thank you. Thank you, Chair. In the report that we read, that I read in preparation for this meeting, it noted that, again, looking at neighbor islands, the Third Circuit, the judges are ready and willing to bring the program to full potential, but DOH requires the necessary resources and facilities on the neighbor islands to bring the program into fruition. There needs to be a statewide vision and funding to enhance the mental health facilities on each of the islands. Could you speak to the DOH needs for this particular program on the neighbor islands and whether you're requesting funding to provide these services in your 2023 budget?
Thank you. Can I defer to you, Dr. Curtis?
So one of the things that Dr. Champion mentioned that I think, thank you for having me here today. Sorry to just jump right in there.
That's fine.
One of the things that Dr. Champion mentioned that I think is important is that when you're going through the ACT process and you bring that, you need to have individuals that are very aware, that are treating the person, know what they need, know what's occurring, know if they've already received other medications or what's occurring. So really we need providers throughout the state that would be able to participate in this. So I think right now what we're looking at is from the Department of Health perspective, we definitely need funding to have more robust education and training for those that are doing it. I think also still looking at the full operationalization of this and how that will work. For instance, you are going to need a good database across the state to ensure that you know if someone's received a medication, that it's definitely known. So if they do end up going to a different county or a different location, a new person is seeing them, they have that order in there, they know that they've received the medication or not. So definitely there's funding that would be needed in those areas. Right now the requests what we have is the bill in there for that increased education and training. We also already have federal funding that we're looking at to do increased training related to our mental health emergency worker system and others in that same area around the involuntary hospitalization, involuntary examinations, as well as looking at ACT. So we're trying to do what we can to build up that understanding of how the system works right now. And then can we start to see more uptake of it if folks are really aware of when it can be used, how it needs to be used, and what they can do to go through the system as it is.
I have a question. You know, the reports on ACT, my staff could only find it through 2017. Is there reports for 2018 through 2022 as to the number of petitions that have been filed?
We do have our reports, so we can get those. Sorry if you don't have them.
Please provide those because,
Sure.
I mean, so I was instrumental, formerly as health chair, to create this ACT program. And my understanding was that we were going to get a few cases, specifically actually from the Department of Health through the state hospital. Did any of that ever occur?
So the state hospital does do something called an AOTT, Administrative Order to Treat, which is different because they're not in a community. So they have a different system for what's used in the hospital in those instances where they need to use treatment over objection.
Are there ever any patients in the state hospital that do make it into the community that would need an ACT order?
There's definitely, when you are transitioning between an inpatient and an outpatient, that is a place where you've got to work together, and I think we still have to do more in education and training and setting up how to operationalize that, where there can be.
You've had 8 years to do that. Have you operationalized that?
No, we have not at this time. We have not yet. And the other thing, I think part of that education and training, we have quite a bit still of using in Hawaii a lot of healthcare providers that are coming in on a temporary basis to come in and help in a variety of different settings. So when you have individuals that are coming in as locums, they're coming in for a period of time, they're a lot more cautious about looking at something like doing a treatment over objection. So that's why I think it's so important to do this educational piece, and that's why we're trying to look at this, because you do have to have the practitioner that's taking care of them has to feel this is the right way to go.
Okay, so let's talk about the patients who are in state hospital that could qualify for ACT. Right, you just said that there are some that could, that if they're going to go from inpatient to outpatient
Yeah.
from state hospital, because one of our concerns is that there might be people in the state hospital who could receive community-based services. What has been the success, or there's just been zero ACTs for qualified patients sitting in the state hospital?
So in the state hospital, they're working on doing the AOTTs. So we have not worked on doing the ACTs. They are trying to have relationships. Sometimes folks come into the hospital with ACTs. We don't even have the data system yet or the communication to know that they're on one officially. So we're trying to work on that right now. How do we know if someone comes in the hospital that they're on an ACT from the community when they came in and knowing what's done? We have a long way to go in our data system and this system.
So Dr. Curtis, I respect that you're probably newer to the system, but I know Dr. Champion and I were here in 2013.
Yeah.
And there was a commitment that there could have been individuals. In the instance when there is an individual sitting in the state hospital that could qualify for ACT, who is the responsible agency to help that individual? Is it a Department of Health caseworker? Is it a caseworker in the mental health program? You folks have not operationalized that since 2013. You've not thought about those things. And maybe Dr. Champion could speak to it.
He can speak early if you want to. I also, just since we've come in, I do want to mention, just because that has influenced this, we did go through the pandemic. So a lot of what we were doing at the hospital was just trying to ensure since 2020 that we're able to still do doing our operations the way we have. And then we've also, during that time, had, as I've mentioned, probably you've seen other hearings, that 37% increase in those that are coming in. So just want to mention that as confounding factors, speaking in my epi language. But here is Dr. Champion to talk about some of the earlier periods.
Thank you. As Dr. Champion comes up, I do want to acknowledge, I understand that, but I think, now as we're following up on these things, and we're talking about placement of people in community-based health services, if they're coming through the state hospital at some point, which we hope there are actually some community-based members who are going to be able to come through the state hospital and not just the criminally intersectioned, the justice-involved patients, right? The state hospital, the new state hospital was intended for community patients. And something's not going right when we see this kind of cycling at the new state hospital. Dr. Champion, if you want to respond to some of the questions.
Yes, and first of all, want to express gratitude for the work of the House and the Senate to support a tool like this being able to be available for us, whether it's in the hospital, the state hospital, community hospital, in the community, and certainly have seen that develop over time. Much gratitude for that. We need that. So a little bit more about the history. You were asking about its implementation at HSH. So we started off in 2013, and we do have reports we can provide to you going back to 2015. And what we see is beginning in 2017, there was the beginning of assessing people for using this for once they leave into the community. And let me back up for a minute. I'm realizing that I should give a little bit of a framework. While somebody's in the hospital, there's a need to engage them in treatment. And if they don't have the insight into their mental illness and are denying treatment, there needs to be a mechanism. And there are two mechanisms or pathways for a clinician to assess and pursue that. One is through a judicial pathway to get it ordered to treat through the court. And as Dr. Curtis was mentioning, there's an administrative mechanism for treatment over objection. That's treatment that happens within your roof, and you're getting them better to then go out into the community. The issue with ACT and how it can be used as a tool is as people are going into the community, if it's established that there's a history of non-compliance with treatment in the community, there is the possibility of going for an ACT petition while somebody's in the hospital and going to be discharged. And what we find around the country is the most common place for that to occur and the most successful is in community hospital settings or state hospital settings. So that is a window of opportunity in a hospital setting to act, but also community-based mental health programs need to act and bring petitions as well. So in terms of a history, what we saw was at first 1 petition, 2 petitions, and then in 2019, it peaked at 6 petitions with 5 being granted, 2019 before the pandemic. Now, I would also agree with Dr. Curtis, the focus of the day-to-day at the state hospital became response to the pandemic, containing the spread of COVID, keeping people safe, staff and patients, and we were seeing that all over the country, that was really the focus of what was happening in the state hospitals. In addition, dealing with the wave of people that were coming in, because to deal with COVID outbreaks in correctional settings all over the country, there was a movement more towards bringing people into the state hospital. So what I would say in response to your good question is that the state hospital did begin to move in that direction. We're successful. COVID began, and now we're going back to recalibrate. But what I also want to add to that is I outlined in the challenges that we have found, there needs to be a designated mental health program in the community that's willing to take a patient who's with an ACT order and implement that, right? So there are 2 parts of it. You have to identify.
Can I interrupt you there,
Yes.
Dr. Champion?
Yeah.
Okay, so in 2019, the 6 petitions, 5 were granted, right? Was that the statistic that you provided? Were those petitions that were pursued by, so my understanding is that it was pursued by like Institute for Human Services or someone in that, or people working with homeless folks? Is that the case, or can you kind of elaborate that? Was it in partnership with like what you would call these mental health programs? Are you aware? Because what made that year happen?
Yes. So anticipating that question, I think what we need to do is get more information and take those cases, unpack them, see what was successful, and whether an organization like IHS was involved in being on the other end of that and agreeing with that. I just don't have that information for you, but we can get more granular information on those cases if you would like.
I think it's really important because when you say you want the challenge is to have designated mental health programs, so what does that look like? Is that the AMHD contract with IHS to provide case management services, temporary housing, or is it a contract with HHHRC that's like setting up these opportunities? I mean, it's just, this is so vague, and what we need is specifics.
Mm-hmm.
Is it, and again, what was it that made those 6 petitions so successful?
Mm-hmm. I understand. About specific recommendations? Okay.
Yeah, I agree. I think one of those that, I know I'm repeating it, but I do believe that education and training is so important, because I think folks have to, those in that time before, again, the pandemic, we were really working on with the different prescribers, the different psychiatrists in the hospital, about how to go through this, what the process was, what it would look like, who would be good candidates, how we can work with those partners in the community to do it. And then when you have a lot of changes over the time and you had a pandemic, now we're starting to kind of look through that again and try to build that back up again. But I think that is what you need, and that's what I was trying to mention. Even within the hospital, we're seeing that real need as new providers come in to make sure they're clear about the processes and how you go through, whether it's an administrative OTT or an ACT, how you go through those process and do that. So I think it's really important.
Members, I see Judge Viola, and I believe he's the judge who oversees some of the ACTs. Maybe, Judge, do you want to come up? And I think I might be hitting a kind of a roadblock for my question, so maybe you can help enlighten it.
Yes, chairs, representatives. I'm Matt Viola. I'm the senior family court judge now in the First Circuit. And I guess I should say we are a fully unified family court. So Judge Kawamura said third floor and third court is the last stop. We're the first, middle, last stop too, for almost all of the bills that plague us right now. If maybe I can just shed a little bit of light on the petitions that have been filed recently. I've just been back in family court since 2021, and I've been doing a number of the ACT cases. I don't have the exact numbers, but I think last year we got about 10 petitions, and this year we've already, I think, 4. Most of those have been filed by Institute of Human Services. They've engaged a private attorney who prepares the petition and packages it, so to speak, and is ready to proceed because they have case managers in the community. They're working with a number of the individuals who are the subject of the petitions. They've already been working them for many years. I understand they kind of keep track and make determinations about who might be eligible or benefit from a ACT order. And they have doctors who are working with them in the community. So there's been an uptick. Hasn't been as much as we had anticipated, but if the current trend persists, it'll be a lot more this year. And almost all. We've had an occasional one from an individual in the community, but frankly, it takes quite a bit to put one of these cases together and present it, and I think it's hard for individuals to meet the requirements that are, I think, somewhat appropriately. There are some high hurdles to meet, just given what's at stake. So anyway, a lot of IHS petitions.
Judge, can you stay there? Because I think this is helpful. I mean, this is your opportunity, and I know you're a judge, so you're not supposed to be commenting on policy, but what is it that we need to improve? Is it the funding of the case management services? So from your perspective, what is it that the system needs to do to improve, to help treat these people?
Well, a couple things. One is, I think these, like someone said before, some of these orders, they're not magic bullets, right? They're a tool, and they're only as effective. Like Representative Kobayashi said before, and judges, we enter orders, right? That's what we do. We decide cases, we enter orders, and those orders, to be effective, they have to be implemented properly in the community. So there have to be a whole range of, I think, resources in the community that make these orders, which for the most part right now are orders to administer psychiatric medication to someone who's living in the community. And so it requires engagement. Case managers are working with them kind of closely. You need doctors out there willing to do that kind of work. You need, like for us, now when the statute was changed, recently we appoint a guardian ad litem in every single case. And there are not many people who are willing to do that work either. The pay isn't the best. It requires sometimes short turnarounds, quick hearings are set. And there's at least some perception they have to go out there in the community, sometimes not to the safest places, and work with a client who may be seriously mentally ill, have a co-occurring substance abuse disorder. So there need, shorthand, there need to be some more resources. I think what I like to describe it as some infrastructure that's built out there, that if this act is going to be made more robust and going to be more cases, that needs to be built out. There are some really, really good organizations, I think, that, not to give anybody plugs, but IHS does a lot of these cases. I used to, like Judge Kawamura and Judge Morikawa, used to be the presiding judge for our mental health court. There are a lot of really good case management nonprofits out there that work very closely with people out in the community, and that's what makes that successful. It's not just giving somebody a shot. It's engaging them and then building out those wraparound services so that once I'm not a doctor, but once they start getting a little bit of that insight, they start improving, they become more amenable to some of those other services that are really the obstacles for them to be succeeding and not getting in trouble in the community. So.
Follow-up questions? Go ahead.
Forgive me if this is a simplistic question, but how does the ACT work in conjunction with the City Emergency Department's core program, the Crisis Outreach Response and Engagement Program? Could you help me understand that?
Probably not a whole lot. I don't see a lot of those ACT cases coming that way, honestly. We will get those petitions filed by, again, a handful of petitions filed by an organization like Institute of Human Services. They may have been referred there. There may have been some crossover. But those petitions being filed on individuals who are already in the community. Sometimes they're filed on, again, by an organization like a nonprofit like Institute of Human Services. For individuals who are on probation or in the court system already, they may be in jail. But for the most part, the number of petitions we've seen are ones filed by nonprofits who have been working with that individual already.
Got it. Okay, thank you.
Yeah, sorry.
Can I turn that question actually to maybe AMHD, or Judge, if you could stay there closely. So CORE picks up someone who's decompensating, may have an ACT order on them. That person might be transported by CORE to Queens for mental health MH1 designation. If we is there a possibility? I heard in one of your things, Dr. Champion, that the medication can only be administered at an emergency room or hospital. But if there was a drop-off center, could there be a qualified healthcare provider at a drop-off center to be able to administer the medication if needed? Is that in the scenario of things that you folks have seen in your travels and visits with Arizona, with Judge Leifman? I'm sorry if I might get his name wrong, Judge Lightman. Can anyone speak to that? Anyone in this group that's here? Because then there's an intersection of the ACT order previously applied. CORE is now involved. Judges aren't involved, but can we help people in other ways?
Yes.
Okay, explain it to
yes,
us
I will.
and what we need to do to get to that.
Yes, I will. Folks have mentioned, or you all have mentioned, the Miami-Dade model, the Arizona model. I'd like to just jazz riff off of the term drop-off center. I think that's a technical piece of it. It's called no wrong door. Right? So the elements of a place like that is there is no wrong door. You can drop somebody off and they're going to get services. At the door, they don't say, I'm sorry, we don't take that. So this actually, in the Arizona model, is like a psychiatric or behavioral health urgent care center that has clinicians who can assess, triage physical conditions, triage you to an emergency department if you need it for the physical health conditions, but for the mental health issues, ongoing assessment and treatment in that environment. So it's very conceivable that if you have a clinician in the emergency department who can be aware of a ACT order and administered in that setting, same thing could be done in a behavioral health urgent care center. And so we're using different terms to describe the same kind of thing. In Miami-Dade, they're now developing the Mental Health and Recovery Center. So it's a whole robust suite of services in a facility that has one component that is a drop-off place for law enforcement. So that's a longer answer to your question. The answer is yes, if it's staffed appropriately. But I wanted to give more detail because earlier there was a discussion about what do we need to fund, what do we need to develop, what does it look like?
So is this drop-off center, intermediate facility, behavioral, whatever it's called, is there a request in Department of Health funding or anywhere in the state executive's budget for this kind of request?
I'll defer to Dr. Curtis.
So there's two different mechanisms that could help in this way. So one, there is a request, we have a request, a revised request in our budget for the area on the Hawaii State Hospital campus called JPAD to take what we have as right now temporary container trucks with stabilization beds that are case management based and make a more robust plan that it could include a drop-off center.
Hold on, so those temporary container structures, those were formerly used for COVID, correct? Or Or they used for?
Yeah, and they
Yes.
still actually can take individuals with COVID. So they're still used when individuals need to go in there because they have COVID as well, but yes.
Are you aware of the funding for that? Was it CARES funding or Ohana Zone funding?
I will have to get back with you.
Okay, because
on
if
that.
this is also a version of Ohana zones, we also need to know that as the homelessness committee to follow up. But
Okay.
that's a side note, so keep going.
So
This is really
those
good.
will not last, in our environment. So we have that request in there to have permanent structure that could help us with both the drop-off. The drop-off centers, many of them, the main part is what we call 23 hours. You're there for only 23 hours. It's a health insurance thing, so you're there for 23 hours and able to get that direct help. And then we would also like to have some of those 3 to 10 day short or less than 10 days, let's say, on average stays for individuals that we do currently under our short-term stabilization bed. So have space for that as well.
So space.
that request
that
is there.
That space at that same area?
Yes.
So
yeah.
it's an area for 23-hour stays as well as 3 to 10 day.
Yes.
So I think this might be a potential site visit for our health committee at some point.
Okay, that'd be
But,
great. Yep, and that request is in there, and it's a $50 million, because that's a large one, so that's in there, but in our request. Then also, one thing that Dr. Champion mentioned that I think is important, and you've mentioned, is the Certified Community Behavioral Health Center. So the way that the Certified Community Behavioral Health Center works, that no wrong door is there. Anyone comes in, there's no eligibility criteria, it's all ages, any behavioral health need can come in and receive services. They do need to have extended hours. As a state, we have our 24-hour crisis line and our crisis mobile outreach that can go out that can handle some of that crisis. So right now it's being built to have extended hours. We would need additional resources to be put in place if we want to make those on the neighbor islands, for instance, 24-hour, rather than using those 3 to 10 day stabilization beds. One of the areas I think is really important is getting these stabilization beds in more of these locations on the neighbor islands. One of the areas we're going to be working on, or challenges we're going to face, is the resources. So right now, when we put a request for proposal out for even a case management based, which has a lower level of staffing that's needed, for that to occur on our neighbor islands, for instance, we're not getting a response from Kauai yet of anyone who feels that they could have the staffing to set that up. We are working on one in Maui, we are working on some on the Big Island, but I just want to point out that we'll have to work on that workforce side as well as having the funding available to get it set up. So those will be the two big issues.
So while I appreciate that it's a $50 million request, I also think that there is an urgency that we're not going to build out a Cadillac system that's going to take us 5 to 10 years to build out to use. We need to find solutions now. And my view is that you have some of those temporary containers that were used, or temporary structures that were used for COVID patients on the state hospital. Those could easily become 23-hour stabilization beds very quickly. And I might be wrong. I mean, maybe, so let's educate us. But, the 3 to 10 short days beds, I mean, what has been the discussions with HHSC Oahu to be able to take some of these potential, convert some of those beds into what you're saying you need, these short-term beds?
So to go back to the container trucks, when you do the 23-hour, you're going to talk about licensing. On average, that's about 1.5 years. So it is going to be a little bit more time to get those up to speed, because you do have to go through set up the program, have it be licensed and go through. That's why we were more, it's a much faster process to set up the case management-based stabilization beds than it is to set up the licensing one, for a reason, because they are getting anyone dropped off. And they have to be able to take care of those. But so there are things that we can do to look at more closely. Related to HHSC, I'm not going to be able to respond to those. I don't know if...
I think that,
Our
so we don't need to
deputy
respond to
director
those
wants
now, but that's part of
Okay.
the calculus. There's all of these assets that we have in the state for potential beds that it confuses me that there's not a plan or strategic plan from the Department of Health. And we can get to that. I mean, I think HHSC is going to be the next one that we're going to have to bring forward. But, there was some discussion about drop-off centers. Does the judiciary, I see Judge Morikawa here in the hearing room. Did you want to speak? Could you speak to any of this conversation we've been having about drop-off centers and the need for potential drop-off centers for the clientele that you're seeing? And if you could, Judge Morikawa, if you wanted to expand on your role in kind of working with mental patients and mental health treatment in the court system. Thank you for joining us.
No, so good morning, all of you. Thank you so much for having me today. So I am basically the judge that's overseeing all of the specialty courts: mental health court, veterans court, and drug court. So in mental health court, one of our biggest challenges is that exactly what everybody's saying, getting treatment to individuals that need treatment. So when they come into our into OCCC, they're not given mental health services right away. For the most part, how it works at OCCC is that it's self-reporting. They do an assessment when they first come in, they do a second assessment from the mental health unit, and if they don't self-report, they don't get treatment unless they're like noticeably acting in a way that somebody is reporting them and they go in. So for instance, I have mental health clients in my program that will get picked up on a bench warrant, and they will not get any services from the mental health unit unless I contact the mental health unit and tell them, this person has a diagnosis. Can you please get them services and get them medication, because I can't put them into a community-based housing unless they've been medicated and have a 30-day supply of medication. So that's why our jail system is a great program. They're doing all that they can, but we're not equipped for mental health. That's not what they're there to basically house people and keep them there and safe but they're not a mental health facility. And I want to say it takes at a minimum, if someone requests to actually go and see a psychiatrist to get evaluated, it can take up to 60 days before, if they're lucky, to go and see one, if they can get an appointment. So that's why the drop-off centers are so important, because you can get the assistance right away. You can get the mental health that you need right away. And we're talking, at OCCC, it's people that have, petty misdemeanors, people that are there on felonies. So I have people that are there on felonies. So they have time, I have time for them to stay there and to get the doctors and to get the help. But people that are there for shorter periods of time, they don't have that amount of time. If they're only in there for 30 days, they'll probably not see the doctor. So that's why the drop-off centers are so helpful, because they can actually see a doctor and get this, treatment right away. So that's why I think we're really advocating for that, because we can see it. We can see that they're not getting the help that they need. And a lot of times, I see it with mental health court, if they're getting the medications, if they're getting the support that they need, my people do well. Don't get me wrong, not all of them are going to be working or but a lot of them are stable. They're not committing new crimes. They're good. So that's one of the reasons why we're advocating the drop-off center.
Can I ask, for those folks who are in the mental health treatment program that need the long-acting medication, is it part of your practice where, as they're transitioning out, that they would get an assisted community treatment order imposed upon them? Or does that not happen at the criminal court level? So for us, for me in mental health court, they've been with their case management and with us for so long that it just becomes a routine. We don't actually do an order, because they're just used to getting their shots once a month. They're used to, or if they're, depending on their level, so if their case manager has to set it up for them once a month, the case manager sets them up, and once they're done with us, they keep their case manager. So the case manager just keeps on doing it. If they're able to oversee their own medication, then again, they still have a case manager that makes sure that they're doing what they need to do. So we don't do that order after. Can I pause that? When you say there's a case manager, is that case manager a judiciary-funded case manager? Is it a Medicaid? Because likely these folks may be Medicaid qualified. Is this a is this a case manager with a community-based program like IHS? Where is this case manager situated?
It depends on how we got them in. So some of them might have had a case manager to begin with already. Others may not have. And so because mental health court is has AMHD services, they get a case manager through AMHD. So we have Care Hawaii, we have North Shore Mental Health, we have IHS, we have a number of different case management services. So the participants can choose their own case management service. If they're unhappy with their case manager, they can ask to be moved to a different one. It also gets to be a little dicey in the sense if we're trying to put somebody in a certain facility, some certain facilities you have to only have case management from that location. So they have to switch case managers in order to go into a certain facility.
Okay, Judge, can you pause there? So I'm listening to all of this, and then I heard previously Dr. Curtis say that we need more infrastructure. It seems to me we have the infrastructure there. It's the coordination of moving these individuals through the proper infrastructure that we already have. Because you're saying we have case management services out there. You're saying we have it. IHS, Care Hawaii, all of these. Yes, I understand that there might be workforce shortages within those agencies, and they're dealing with burnout as well. But is it a matter of funding some of these programs and adding additional funding? And maybe that it's not fair to ask you. Maybe I can,
Yeah,
I can ask
I would
both of you.
assume that they would probably need more funding. I'm assuming everybody needs more funding, so I think that's an easy answer. It's an easy yes, so that they could have more case managers, because I see the same case managers over and over, but I agree with you that there are very good case management services that I see all the time that are working really well with the people that I work with, with the participants of my program.
Okay, so can I put a pause there and I ask Dr. Curtis to come up? Dr. Curtis, we're hearing that there's infrastructure out in the community. Can we scale them up so that we don't have to create new programs? The programs are there already. How do we scale up the programs that are working?
Yes, and we can do more. So I'm not saying we can't do more. That's what we're trying to do. I mean, that's why we created the stabilization bed, system that we didn't even have in place, and we've created that. That's what we're moving toward. That's why we have these requests in to do it. So we're working. We can always do more, but that's exactly what we're trying to do. So we've added the CCBHC model. We've added these short-term case management stabilization beds that we never had before, all through those contracted providers in the community that you're talking about. So we're going to continue to work on adding these systems, and that's why we know one of the next steps is this drop-off center, and we're in complete agreement we need it, and so that's why that request is there. I realize we want to move as quickly as possible, and we're trying, and our system is sometimes not as quick as we would like, but we are in agreement and moving in that same direction, trying to do the same thing.
Okay.
So.
Members, it's 11:19. I know I promised getting us out of here by 11:30. Any further questions? And I want to recognize that Vice Speaker Representative Gregor Iligan is on this committee. Representative, any questions for any of our distinguished panelists? Dr. Curtis and Dr. Champion, I'm sorry. So we do have until 11:30. Were there any kind of closing remarks or any kind of other comments that you would like to make before the committee? We do have an additional 10 minutes for anyone else who wants to just maybe add anything.
I just wanted to make a follow-up comment. In order to develop solutions with success for people who are suffering, we need a comprehensive array of services that's integrated and coordinated. So whether an individual is coming into the emergency department, or they're connected with a mental health provider in the community, or they come to the courts, they're in jail, there need to be mental health services that are appropriate and scaled to the need. And this is something that is a very understandable goal, and it's also challenging but doable to do. And states all over the country are working to achieve this, identifying the gaps in that array and filling them with the very questions that you're asking about what are the PUCAs, what can we do to support it. So one of those gaps that you find all over the country, you find here in Hawaii, is a receiver of folks who are in crisis to provide assessment and linkage and treatment. So the technical piece, as I said earlier, was dropping somebody off. That's typically law enforcement dropping them off. You could call an emergency department a drop-off center. It's a place that will receive individuals who are in crisis, assess, stabilize, treat, link, and do what you need to do if they need to be in the hospital or in the community. So the Behavioral Health Crisis Center, or equivalent name to that, is certainly a gap in our community that we need to build towards innovatively and make short-term progress and long-term progress on that. So thank you for the questions about that. I think you're honing in on a very, very important gap that needs to be addressed. We're aware of that and we're working on it.
Before you go,
Chris?
Dr. Champion, may I ask a quick question, Chair?
Absolutely.
One of the two requests that it sounded like you were making for funding was a database. Is that, no, yes? Because it sounds like that we need a good database that we can then quickly access for folks who have been participants in this ACT program, so we know what medications they're taking and don't double up, as you were saying. Who can host the database, and how's that going to happen? We need to institute it.
So one of the things that we're using our federal funds for right now is to increase our data system to be able to do that and be interoperable with the other systems so that we'll be able to see them. So that is going on right now. Through this special project, we've already been able to bring on, I think, 11 to 13 individuals that are working on building the electronic system so that it can work, so that we are able to get information quickly, share with all the other providers, and look across that system. I do think one of the other pieces that could be looked at is making sure that the electronic record also for Ph.D. in jails and corrections will
Yes.
equally be able to be interoperable and be able to share, and that'll be an important piece too to look at. But that's one, we're working on it right now. We're working through the time, but that's an important one, and it's going to be a game changer when we're done, and being able to quickly look, see how we're doing with programs, not use manual records, not be having folks wonder, is this person really on, at ACT somewhere? So that is currently ongoing right now. So we're very happy that we have that federal funding, and we're using our federal funding sources to be able to
What's
do
your
that.
expectation on the completion of that program?
It was a 3-year project that started last summer, but we're already getting, going through procurement for the EHR system that would include all the requirements that were put in there, and that's supposed to be put in place next year, at the beginning of the year.
Thank you.
Yeah.
Thank you, Chair.
Members, any further questions? I'll just make some closing comments. I really want to thank, go ahead, Dr.
Could I
Curtis.
take 1 minute? I'm
Yes,
sorry.
absolutely.
Okay, I really want to thank everyone for having us. I know it's a little different being up here and having to hear these, but we are so appreciative that there is attention to this, and we know how important it is in a community to have these resources. I wanted to just reiterate a couple things. We do have strategic plan. That strategic plan includes many of the things you've heard about today, filling out the continuum of care in the community, including for those with co-occurring substance use and serious mental illness that have not done well in other facilities, being able to include these crisis stabilization beds and increase the use of them, including these 23-hour or drop-off centers, being able to build back up a robust jail diversion system, looking at all the different continuums or locations on a continuum of care where you can have that diversion, right, and have that occur. One of the important things I want to mention is we do have to make sure that we have the staff, that we're able to pay them what we need to, and we're able to hire them. I know we had mentioned with Act 26, there were questions about if there would be funding requests for Department of Health, if it was expanded. We are definitely short on court-based clinicians. They do an amazing job. I mean, you've heard Dr. Bautista Torres mentioned. We have individuals that go in there, do these evaluations very quickly, and go back out. That's something we need to make sure that we have enough of them on a neighbor island. Folks are right now having to care for multiple islands and hop across to be able to do that forensic coordination work that's so important. So we will look at those, and those are in there for requests to help with that. But we really appreciate working as a team. I think all of these different stakeholders have to work together, and we've been communicating quite closely with everyone to figure out how we can do it, and look forward to continuing to do that through this session. So thank you.
No, I want to reiterate my thanks, Dr. Curtis, Dr. Champion. You can sit. I know that you guys have put together this sequential intercept model and community resources, so I know that there's a plan out there, and we need to really dig into this. This is only the start of the conversation for this committee. But I do want to say, and just slightly summarize some of the real nuggets that we got from this briefing, that we know that there's going to be changes that we need to make to Act 26, maybe look at expanding some of the offenses over which that we can cover it. We're going to have to be looking at behavioral health crisis centers and the interconnection. We're going to have to be looking at maybe some probation issues. And so this committee will be working on a bill that's going to address some of the suggestions that have come out of this and other suggestions from our community partners. And we will be moving certainly something in this area relating to rehabilitation, because this is a critical piece for our house. It is a critical piece for our community. And I really want to thank you for helping us start the year off right with such a rich informational briefing. Seeing no further comments or questions? Yes, go ahead, Chair.
To both chairs, Tarnas and Bellotti, thank you so much for having this informational briefing. Judiciary, Department of Health, thank you so much. We look forward to partnering with you in our endeavors. A number of bills are going to be hitting our hearing soon. Please, I highly recommend for bills like this, contact Chair Bellotti and feel free to walk her through what needs to be done, what doesn't need to be done. She's a great, I guess, technician on bills, but we also need your insight to help us craft this piece of legislation. So again, Judiciary, Department of Health, thank you so much for being here. Chairs Tarnas, Chair Bellotti, thank you very much. Job well done.
Thank you. Seeing no further questions or comments, this information briefing is adjourned. Thank you.